I'm Joel Meskin, Vice President of Community Association Insurance and Risk Management. One of the most frequently asked questions we have is, if there are multiple entities that share governing documents and share a board and share financials, can they be covered under the same D&O policy? This is a situation where, in all practical matter, there may never be any conflict of interest, there may never be any problem. However, in this situation where you have separate legal entities, it really is appropriate for each legal entity to have its own directors and officers liability policy. Yes, there may have never been an issue between two boards. Yes, there may have been no issue between the two associations. However, if there in fact are two associations, then logic has it that you should have your own D&O policies. One of the common tenets of a fiduciary obligation is that how can you serve two separate masters with the utmost loyalty? You can't, and therefore you really need to have separate boards and at minimum separate policies to provide coverage in those situations. So unless there is one such association which is a subsidiary of the other and for all intents and purposes controlled by the other, or if there is a separate operating agreement that allows one entity to make decisions for another, you really do need separate D&O policies. That doesn't mean that property policies or general liability policies may not be able to be shared, because there's a difference there, because you're dealing with specifically property and general liability, which is generally managed through a management company. So in those situations it may be appropriate, but with respect to directors and officers liability, where you have insureds with a fiduciary obligation, it's a different scenario.